My Lord, the state will be recalling the previous witness, Lieutenant Colonel Rapadu, but a debate has arisen between the state and the defense as to the injection or the transplanting of the evidence of this witness from the evidence that was given in the trial within the trial to the main trial. We were trying to reach an agreement that the evidence that he gave in the trial within a trial, keeping in mind that the trial within the trial is a watertight compartment, that the evidence that he gave in the trial within a trial be transplanted or injected in the main trial, but we couldn't reach consensus on that point, and we just briefly want to address the court on that. In the earlier decisions, and I'm referring to the case of State versus Sitebe, the citation is 1992, Volume 2, SACR 346, and is the decision of the Appellate Division at page 351 from paragraphs C.
Wait. Mr. Ngomezulu, have you listened to your colleague?
Yes, ma'am. That's correct.
So what is your decision?
My Lord, as it has been discussed that the witness will proceed from where he ended on the evidence that has been redacted, because the evidence that is tendered during the trial within the trial should be, this witness should continue by giving evidence or reading the statements that were attached on a pro forma, which were redacted during the trial within the trial.
Is that the agreement with the state?
Yes, that's
but
what.
Mr. Balu is not saying that. Mr. Pidi, what did you agree with the state, if anything?
If anything, my Lord, we did not agree, but my position is that, my Lord, since the trial within a trial was insulated, and now we are no longer dealing with admissibility, my take is that that evidence now forms part of this evidence, because he's continuing with the annexure. We go into the parts that were withheld for the purposes of the trial within a trial, my Lord. That's my understanding, subject to.
Mr. Nisi?
That is my understanding as well, Madam, and which is the reason why there's a point where you want to take up the witness on this evidence in the trial within the trial. There's nothing that bars us from doing.
You want to take up something with the witness?
Yes.
In a trial within a trial?
In the evidence that he provides in the trial within the trial, you can still go back to his evidence in the trial within the trial and take up him on those issues.
Yeah, fine.
The reason why that evidence will basically form part of the main trial.
Which evidence are you talking of?
I'm talking about the evidence.
The pro forma evidence?
Yes.
Yeah. Yes, Mr. Mumalu?
Thank you, Madam.
The court has made a ruling.
Hello?
The court has made a ruling about the admissibility of the statement, so it is for the witness to continue from where he ended on the last occasion. Thank you.
Yes, Ms. Mchololo?
Thank you, my Lord. My Lord, also to add on that, it's that in the pro forma itself, my Lord, you'll recall that there were other paragraphs which were blocked.
Yeah.
And then now they have to be revealed and read into the record. That's the procedure that we need to follow from now onwards, my Lord.
Okay.
Thank you, my Lord.
What are you saying?
Well, we are saying, my Lord, that there has to be some sort of an agreement that the evidence that was given in a trial within a trial of a specific witness be injected, be transplanted in the main trial so that this witness doesn't have to repeat what he testified to. Must keep in mind, as Mr. Ramusipili mentioned, that trial within trial is watertight, is insulated. So basically we're starting now on a clean slate, and it's crucial that, and this is what the authorities are saying, that, there has to be, that agreement.
Just read those authorities as you say.
Yes.
You say
Sitebe. Starting with Sitebe, my lord,
Yeah.
1992, volume 1, SACR 346, the decision of the AD at 351 C to D. This is what this was
who
the
were the judges there?
yes. The judge was Van Heeren, Ninaber, and Nicholas, AJA. Initially, they laid down a very straitjacket approach, and in paragraph C to D, they held as follows: in principle, unless the parties stipulate to that effect, neither the defense of the accused nor of the state witness given during the trial within a trial ought therefore to be injected in the main trial. So in other words, they say there has to be, an agreement to that effect.
So that's inclusive in the pro forma evidence.
Indeed, my lord.
Yeah, because
Yes.
that is, if you want to be fancy, it's res judicata.
Yes.
Okay.
Yes, but this approach was later watered down, my lord, in the very same SCA in the matter of State versus Nhlengetwa.
Ntlengetwa, okay.
It's
Which year was it? Ntlengetwa?
1996,
Oh, good.
volume 1.
Yeah,
We'll remember the Siteba was earlier in 1992, so 4 years later,
yeah.
in the matter of State versus Nhlengetwa, 1996, 1, SACR
Age.
at 737,
Yeah.
and here the bench was Appeal Judge Smallberger, Grosskopf, and Narams, and they held as follows. I'm reading from the head note at the bottom of the page. In SD Fries 1989, volume 1, SA 228, appellate division decision, it was held that an accused evidence during the trial within a trial could not be held against him in determining his guilt.
Yeah.
I'm sorry.
Yeah. No, fine.
This does not mean, however, that those parts of the state's evidence relevant in respect of guilt and which had been presented before the full court cannot also be taken into account. We go on. If a trial is conducted by either a judge alone or a magistrate, it is nonsensical and a waste of cost, time, and energy to repeat evidence which was presented during the trial within a trial at the end of such trial within a trial. So in other words, my lord, they say it's not necessary to repeat the
Those are 5 judges. 3.
three.
3. Rams also.
Yes.
That's what the law says. Now, I'm surprised Mr. Mnisi says there are issues which he wants to take up with the kennel regarding his evidence in the pro forma. Is that what you're saying, sir?
Basically, the process here is, and the court would remember that.
No, let's, is that what you're saying? You want to re-cross-examine this witness regarding the pro forma. Let's not complicate the law.
What I'm saying, my lord,
Yeah.
is if there are aspects that this witness testified about
Where?
in the trial, within the trial, on the performer,
Right?
and I want to take him up on them,
No.
I am welcome to do that.
No, you're not. Quote me the authority. Jen, quote me the authority.
That's the procedure.
Yes, quote me the authority. He's been quoting the authority. I don't know that procedure.
Otherwise, that is going to be very irregular.
No, quote the authority.
I might not have an authority now, my lord, but that's the
No,
procedure.
Alder Jen. How many days do you want? Alder Jen, quote the authority.
Okay, no, it's fine.
No.
I-
You can't make a statement about the law, and when the judge says quote the authority, you say, no, it's okay. Sir, Mr. Balui, do you know of that authority? Which says you can again cross-examine this witness concerning the pro forma after having done so.
Yes, yeah.
Hello?
Well, there's that case of Krecher by Judge Lamont, which says the court should adopt a somewhat flexible approach. It will be up to the court to decide whether it allows such cross-examination.
So that judgment was written by Lamont.
Yes, in the Krecher case.
Do you have it here?
I'll be able to look. I don't have it at hand. But
Do you have any judgment besides the judgment of Lamont?
No.
You're sitting alone.
No, I don't have any other judgment, my lord.
Do you have any judgment?
No.
Either even if it's in Namibia
No.
or even in Zimbabwe, which says
No,
exactly what Mr. Mnisi is saying.
no. I'm not aware of, except for this one that I've quoted.
Okay, let's hear the other authorities.
Yes, continue from where we left off. There's that other matter of State versus Bakani and others.
Yeah, I'm aware of that.
It's 2017, Volume 1, SACR 576. This matter went on appeal, and
Before preliminary.
the SCA did set aside the judgment on the merits. However, some of the principles that were distilled remain in place. For instance, on page 582, paragraph 20, the court says the following: as it is usually happens in matters of this nature, the parties in casu agreed that the evidence led by the state in the trial within a trial will form part of the main trial to circumvent a situation where the witness would have to lead the same evidence
Yeah, that's the law I know.
and be subjected to cross-examination
Yeah.
again. Yes, I think just underscores
Yeah.
what
I've
the,
never heard of that. Never, ever.
what
Been in
the-
the criminal courts donkey years. Okay,
yes. Then perhaps the last case then is that one of State versus Muchindu.
yeah, that's
yeah.
where he says sometimes you can't differentiate between the evidence, which, just read it also.
Yes,
Because Mr.
it's
Ngumalo
two-
once read it.
It's 2000, Volume 2, SACR 313.
Yeah, what does it say?
Shoots
Shoots, yeah.
Day, yes. It says, and I'm just reading the headline, the head note: it is not necessary for evidence which has already been led in the main trial to be led in a trial within a trial. If the parties wish to refer to such evidence and the court is entitled to rely on such evidence. And then on page 317, at paragraph H, he says, accordingly, I rule that during the course of this trial within a trial, reference may be made to evidence already led in the main trial and that the court is entitled to rely on such evidence as may be appropriate. My Lord, he's just saying that,
The opposite.
yeah,
That is permissible. Where,
he's
for
holding
instance, the colonel says I was born in 1920.
yes. And
Then you
just,
can come in a trial within a trial, that evidence can be admissible.
yes,
It's the other way around, because that is the merits being infused
yes,
into the evidence in a trial within a trial, where it is common cause.
yes, yeah.
Okay.
And then lastly, the author Himstra criminal procedure at 2462,
2462.
yes, 2462,
What's the him, sir?
in the heading repetition in the main trial of evidence given in a trial within a trial, he says, when there was a trial within a trial, those parts of the state evidence which are relevant to the main trial can be taken into account without being repeated. Says it is an unnecessary waste of money to repeat that evidence
fine.
in the trial. Then he quotes the decisions of Nhlengetwa as well as Muchindu.
So basically, those decisions are saying that what has transpired in a trial within a trial, meaning including the evidence which was led in the pro forma by the person who ultimately writes down the statement or the confession.
Yes.
And he or she has been cross-examined. So are you saying they're saying there is no procedure which says he must also be cross-examined on the evidence led within a trial concerning the pro forma?
Yes, that is the effect of the
That's how I
judgment
understand the law.
that we refer to.
Yeah,
Yes.
but it happens with any, he doesn't have to be in a trial within a trial. It happens, as Mr. Ngomezulu can tell you, it happens with any evidence. Once a witness has been cross-examined, you can't cross-examine him again unless you get a special dispensation from the court and unless there's a just cause which you present.
Yes.
Okay, what
Okay,
else?
then just finally, the writer Ditoi
Tell you, what does he
and
say?
others' commentary on the criminal procedure at 2466H
Yeah,
poses the question, if an accused evidence during the trial within a trial cannot be held against him in determining his guilt, that is now in the
you can't.
trial within in the main trial, does this mean that those parts of the state's evidence relevant to his guilt can also not be taken into account? Then the writers say no, said the court in S versus Nhlengetwa, provided such evidence has been presented before the full court, including the assessors where they are sitting with the judge. It would be nonsensical and a waste of cost, time and energy, said Harams J.A., to repeat evidence which was presented during the trial within a trial at the end of that procedure. He recognized that such a step might be a deviation from existing practice, and he also refers to the case of State versus Bakani and others, where the majority referred to Nhlengetwa's case in holding evidence adduced by the state at the trial within a trial to be admissible at the main trial for the purpose of confirming the confession. So in short, my lord, our contention is that the evidence of the witness who have been recalled, because basically this witness is being recalled, it's already testified.
That's it, yeah.
And I think that is the effect of the
law.
The submission by Mr. Ramsepeli and Mr. Ngomezulu that
Yes.
they continue from where they left off.
Yeah,
But
that's
just,
what the law says.
yeah, but just to avoid any uncertainty in this regard, we submit that the evidence of this witness on all those witnesses who have been recalled or to formally be injected or transplanted in the main trial.
Okay. Any response from any person, any counsel? Mr. Ngomezulu, you stand by what you said.
No response, man.
Mr. Ramsepeli?
As the court pleases, my lord, I hear the authorities and I cannot off the top of my head because the one that I had was the culture one because
Which
I've
one?
got it here.
Which one?
The culture matter. But my concern, and I concur with Mr. Muniz, is this. There were certain parts in the pro forma that were redacted that the witness that's been recalled was never
They never
cross-examined.
testified on them.
So we leave them as
Yes.
that. Then I'm indebted to the
Even
court.
this court,
Yes.
you all refused for this court against the law. You refused that I should know what is redacted. You remember?
No, I'm
You remember
indebted
that?
now.
You refused, and I said, okay,
Yes.
having quoted case 1952, quoted an SAA case
Yes.
of 1952, which says, I can and I should. But I just abided with what you were saying.
No,
Now,
we-
those redacted parts, he was never permitted to read them,
Yes.
and they were never read. So he's not going to read them.
Okay. No, I'm indebted to the court.
Yeah. Okay, let's start. Can you swear the witness in again?